police brutality in the recent Bersih 2.0 rally. Less successfully is trying to get motions debated in Parliament. At the moment in Malaysia, even though the ruling coalition does not have two-thirds majority, but they still have overwhelming majority. So bottom line is any motion that's proposed just gets squashed. The other thing which we do is rallies in real life and also online campaigns. So again, back to the 2.0, Bersih 2.0 rally that happened recently in Kuala Lumpur, that was really successful. But tied in together with that was also a lot of use of online campaigning. So when the events were happening, there were also other campaigns which were happening around the world, and we had photos, we had videos, so it just feels like a great sense of solidarity. Now, the last point that I'm going to talk about actually is court challenges. So that's still one of the key strategies that we use. But it is excellent, and it is also problematic in so many areas, because using the court can be extremely disempowering. I would say that one of the things that you really will need is an independent judiciary, which in Malaysia, actually, you don't have. And also, you will need lawyers. You need lawyers who are essentially going to do things for free. You need to get the lawyers educated in the human rights law, and all sorts of things. So the recent Bersih 2.0 challenge that has successfully happened actually yesterday. The minister had actually banned Bersih 2.0, saying that it's an unlawful association. So we filed an application in court to review the minister's decision. So we heard yesterday that the court had actually just granted leave to actually do the challenge. But of course, it's only the leave portion, so we don't actually know the substantive challenge, whether she's going to say yes or no. So at the moment in Malaysia, you kind of have certain rights not so, which I suppose the government doesn't feel challenges the political status quo. We have had some successes. So for women's rights, recently we had an excellent decision. But political decisions, decisions that have a political impact have not been so successful. So actually what I would like is to hear from the people in this room, what sorts of substantive laws and rules of procedure, and especially evidence, because this is the other big problem about court challenges, is that things are happening too fast and the laws are not catching up. So we're still dealing with very old-fashioned kind of rules of procedure and old requirements of evidence, which doesn't fit into this new world anymore. Thank you.
Thank you, Honey. And it's really refreshing, I think, to have us critiquing the strategies that we're using. I think sharing them and saying what's working, what isn't, is really helpful, and particularly around how we can build solidarity around that. So thank you very much. Now I'd like to ask Shahzad Ahmad from Bites for All, an APC member in Pakistan, to respond to the same question. Shahzad.
Joy, there is one national perspective, but before that there is a bit of international perspective to it as well. That just to give you a backgrounder, and then since we are sitting at a UN space, Pakistan coordinates OIC countries, all Islamic countries at the UN, and it has its influence, negative or positive, but its influence on larger Islamic world. Many of you would know that Pakistan is inventor of faith-based filtering. And then a lot of other Islamic countries followed Pakistan on that. And faith-based filtering in the sense that, they would tell you that we are filtering or we are blocking internet for blasphemous content. But when you dig out this whole saga, you would know that they're only blocking political discourse or criticism on the government. I can give you one example. In February 2006, government blocked a Wikipedia page that had caricatures on it, and that caused a whole Wikipedia blocked in Pakistan. Now that page is openly accessible. No one is blocking it. But there are other websites, which I'll mention in later, which is essentially political discourse from Balochistan particularly, that is blocked. Having said that, okay, I also want to mention that we have documented all these facts over the years in last like 3-4 years. First for our ONI research that we were doing, Open Net Initiatives research that we were doing. Then early this year, we did the Freedom on the Net report, 2011 for the Freedom House. And recently, we have focused Balochistan from human rights perspective for our Global Information Society Watch report that is going to be launched in November, I hope. What we are seeing is that the whole freedom of expression and freedom of assembly, since traditional media can be controlled and managed. We are a democratic country, and we have democracy in Pakistan, but still, traditional media can be controlled and managed, but internet continues to haunt repressive regimes and the governments. And they have played with this whole digital communication sphere and really made mess out of it. So just to mention that what they would be concerned about. They would be concerned about national security. They would be concerned about anti-state element. They would be concerned about religion. They would be concerned about culture, and essentially war on terror that is, continue to wreak havoc in Pakistan. So you wouldn't believe that at times for the content on the internet, actually there is one very draconian act, which is Anti-Terrorism Act, that comes into practice, unfortunately, and that is it's really draconian. And then Article 295C of the Constitution, which has capital punishment for any blasphemous statement or content, that is also, we have seen, been exercised. And that is why we cannot get any legal support, because last year I was crying that there is no support for legal litigation, and there is no support to go to courts to seek justice on all these issues and why they are doing it. And this year, the issue is that no lawyer is ready to take up this case. We have money to do litigation in the court, but unfortunately, we do not have lawyers who would be brave enough to go in the court and openly debate Article 295. They think that when they would argue, Article 295C will come into discussion. So we have gone to some top-notch leading lawyers in Pakistan in last like 1 to 3 months. They have refused. So that is another challenge. The recent example I can quote you is that Pakistan have banned encryption in Pakistan. What they've done is that they think that terrorists and anti-state element are using encryption, and they think that Taliban particularly are using encryption and using digital communication, and they are doing all this terrorism in the country. Okay, this ban actually makes us vulnerable as well as human rights defender, as civil society workers, because if you use encryption, you stand suspect, and even if you have not done anything wrong, but still you are a suspect, and they can pinpoint you and they can pick you up. So that's a lot of problems. So what we have done so far is that we have what we could do little about it, that we have reached out to several international partners. We have reached out to APC, Freedom House, Article 19, MLDI, Media Legal Defense Initiative, Privacy International, several of the organizations. We have reached out to them, and now we have issued a very strong statement, which actually first time ever in Pakistan challenges governments this notion of national security. probably this is first time we could do it, that we have challenged it, that the national security that you bring in everything is not going to work anymore. And then we have written a joint letter to the Prime Minister as well, though as expected, we haven't received any response on that. So some of the key issues which I think, I mean, I can go on and then I can quote other examples as well. For example, recently a music website was blocked about 2 months ago. Rolling Stone, I don't know if you would have ever heard about it. I didn't, I mean, until this website was blocked in Pakistan. So this website was blocked only because it had 6 lines criticizing on Pakistan Army's spending. And I mean, it was taken from an article in somebody written in probably Washington Post or New York Times in America. And there was only 6 lines of mention of this in a blog. And they blocked whole domain. Another issue that we are seeing is that some of the ISPs now, without any direction from the government, though they write very clearly that blocked on the advice of PTA, blah, blah, blah. But they're doing it. When we reach out to PTA, they say, no, I mean, we're not blocking anything. But there are several websites with, I mean, they think the being moral police or whatever, I mean, they are also, I mean, continue blocking this content. Okay, I mean, quickly, I mean, 3 things I want to say. The key issues being faced are inaction on the part of judiciary. I mean, we have seen, number one, nobody is investing in judiciary and lawyers, legal branch in countries, in repressive countries. I mean, this is extremely important. We have proposed several times to the organizations who are working in these areas that now is the time that you need to work with the judiciary and the legal branch in the different countries so that they are aware how this whole communication sphere works, and then they can take action. Because courts are also being used to violate the freedoms and the rights enshrined in the Constitution. So I mean, blocking the website, even courts orders it. It means that the Article 19A of the Constitution of Pakistan is being violated, but they just don't understand. They only think that what the petition is, and it's blasphemous block. But it is not blasphemous content that is blocked. They use this reason to block several other things which are against human rights. Legal protection for the citizens, we do not have any laws which protect citizens in terms of privacy, in terms of their use. While I know Council of Europe is heavily trying Pakistan to get their cybercrime convention signed by and ratified by the government of Pakistan, but they really don't know that we do not have basic protections that EU governments have access to already. Then I see our regulator as hegemonic, and then also what we can do is that we are trying to invest in digital security of the human rights defender. We are doing trainings, we are working with them, we are campaigning, we are reaching out to the international different human rights friendly organizations, human rights friendly governments, and we are trying our bit. Let's see how it goes. Thank you.
Thank you, Shahzad. And I think it's certainly striking, both with you and Honey, the degree of surveillance that's obviously going on in terms of the sorts of responses and issues that you're encountering. I just want to briefly open the floor at this point and just ask if there's anyone who wants to comment on either the questions that Shahzad and Honey have raised, or from their own experience in terms of the critique of the issues that they've raised around different forms of accountability. Please, your comments, observations, thoughts would be welcome. Go ahead. Please introduce yourself on the mic. Thanks.
Paula Schrieffer from Freedom House. I've had some conversations with Shahzad about this in the past, but I'd also be interested in Honey's perspective. In terms of both of your countries, obviously you've worked with international freedom of expression organizations, obviously APC, Shahzad mentioned a bunch of others as well, but what do you see, what institutions, whether multilateral organizations, regional organizations, or international organizations, do you feel have the most legitimacy with your governments to help you in your advocacy and your work back at home? Is it the UN? Is it regional groups? I'm just curious.
You take first?
Can I add a question before they respond? Henriette Esterhuizen from APC. Just a question about the type of violations you experience. Is defamation and the use of defamation law being used, as it is, for example, in South Korea? It's actually happening. I think journalists are increasingly, even in Africa, where there's not a lot of filtering or direct censorship, but there is quite frequent use of accusations of libel to silence criticism of the government. And then just the other question related to that is, I think you've touched on that, Shahzad, but that is the link between need for freedom of expression to address corruption, and how do you find responses from the private sector to these violations of freedom of expression? Is the reaction against it something that's kind of restricted to media groups and human rights groups and activists? Or do you also find from the corporate sector some kind of demand for more freedom of expression linked to transparency and accountability and making it a stable economic environment?
Okay, I'll just, before we lose the track of the questions, I'll get them to respond to the first two.
Yeah, I already probably forgotten the first question, but
the question was which forums or regions would be most helpful.
But from Pakistani perspective, it is extremely important that the campaign or the initiative or the fight is really local. It's only then it will be original and authentic and credible. Because as soon as you link with, some other, the networks you mentioned, the finger pointing starts. So what we have done successfully is that we have organized and allied with credible, internationally renowned organizations who are known for their work. So, and then we have always been on the ground. We never, did something from out of the country. So that was important for us, that we are in the country and we do what we want to do from there. So it is one aspect to it, and we are ready to work with any organization who support our cause or our work. We have been working with APC for a long time, but we are now working with other organizations as well. So it has been a great association so far. On your question, Henriette, they have used. there are several different laws, and it's quite chaotic. But they can use defamation law. They can use. I mentioned blasphemy clauses in the articles in the Constitution. Then Anti-Terrorism Act that is being used, and there is electronic transaction ordinance that's been used recently. Somebody hacked president's website, a young boy, and then he was put in the jail. Using this particular ordinance. So there are several different laws being.
Thanks, Shahzad.
Okay, just a very quick answer. Which organizations would have a greater legitimacy with our government? I would say definitely the United Nations, because Malaysia postures itself in the international arena as this liberal kind of Islamic country, which actually we're not. I would say and it's also important, I keep emphasizing this work with the national human rights institutions, because I think maybe a couple of years ago, we had this very big colloquium, which is organized by Suhakam, and they brought in the regional representative from OACHR from Bangkok, and they were able to compel, practically from top to bottom, the people in the judiciary to come and listen to this talk. So that's a part of it. The other thing I think is really key is actually judicial training. But I don't think it's going to be working so well if you bring like foreign judge trainers into Malaysia, because then there is still the whole culture. You see, Malaysia, everything is very patriarchal and hierarchical. So if you have an in-country training, you know, somebody who's lower down the judiciary will not open his or her mouth when the boss is there. It's better, I think, to actually pick 3 or 4 and send them abroad in a mixed kind of situation with judges from other countries. Huh? So that's one of it. Now, other regional groups, I would not recommend ASEAN, the Association of Southeast Asian Nations, because of the 10 countries we have, you know, Burma, which is kind of like a military junta ruling the country. Then we have countries like Brunei, which is an absolute, like, you know, it's a monarchy. You have the whole range, right? Then you have on the other hand, I would say, like, you know, Indonesia and Philippines, and Malaysia is kind of like, you know, in the middle somewhere. Now, defamation, yes. In Malaysia, we have 2 kinds of defamation. We have civil defamation and criminal defamation. So most recently, Charles Hector's case was a classic case of a Japanese MNC, you know, trying to squash him, and he was forced to settle his case. Criminal defamation is always threats going on, and also if you're a blogger, like the Raja Petra's blog, you know, all sorts of things happen there. So, thanks.
Thank you. I know we had another couple of questions, and I've got you, but I'd actually like to move to our next speakers first. So I'm running a little speakers question list. Just because I'd like to move topics slightly, I'm going to ask Biddy Bala from Fansuam, another APC member, this time based in Nigeria, and Anya Kovacs from India. And the question here is, can restricting or shutting off access to the internet ever be a legitimate remedy for internet rights issues? And what's the difference between doing this for intellectual property rights violations and doing this for national security reasons or to penalise for online child pornography offences? And then perhaps just reflecting on that, so how does that relate, how do those issues relate to internet governance? Bala.
Hello, everyone. I just attended a workshop about the erosion of our privacy on the internet, and it was actually scary and eye-opening. I didn't quite realize how easily our information, I mean, it's all over the internet, and somebody mentioned about the how people now sell people's data for, I mean, money, you know, big companies. So I'll say I'm tempted to say that there's actually no grounds for shutting off the internet, because if people are committing crime through the internet, the law enforcement needs to find innovative ways of punishing these people through conventional means, you know, going to jail and things like that. But of course, that's another discussion. So basically, there just needs to be a balance between internet access and the way law enforcement handles these issues. I think that's basically why we're here at the IGF, to debate more on some of these things. But then when I look at it, actually, I don't know if this is the right question, the one I'm answering, but I think that what we should actually be looking at is the person violating or breaking any laws, that is for his internet to be shut off, and what methods, and in that case, how did the law enforcement find out that he's breaking these laws, and how did they track or get this information? Of course, I'm sure everybody here will agree that child pornography is something that if you get hold of anybody doing it, the person needs to be punished severely for that. But then still, we still have to think about how people track those who break these laws. From our experience, or from my experience in Nigeria, I know that when people are sufficiently scared, like for instance, with all the bombings going on, they are willing to let go of a lot of their rights so that government can handle, can handle the situation. I mean, they are willing to give up some rights at least so that peace will return and people can get about their lives normally. But then, of course, we all know that national security is something that many governments all over the world use. It's a very gray area, and they, once they term anything national security, they can pretty much do whatever they feel like. Right now, it's a challenge because people are beginning to feel that that whatever government does in protecting our national security is right because they are so scared. For instance, yesterday was a deadline that everybody that owned a SIM card, a mobile on mobile networks in Nigeria had to register. And registration means going to a registration center, having your picture taken, your fingerprints, and your address. Yes, I had to do that, and I have 4 different lines, so I had to register on 4 different networks. So people are happily going about doing it because the government says that it will be easier to track those people that are sending messages about bombing places and some of these terrorist people that we're beginning to see. But then the question now is going to be, after all that threat has been taken care of course, we've heard about abuses of some of these things. The thing is, I mean, it's so that this will mean that there's really nothing you can do with your mobile phone. And of course, the mobile phone is the most accessible device in Nigeria for internet, for communication, for everything. We don't have landlines. So everybody has gone and registered now, and it's in a database with their picture and their fingerprints, and they can track you down anytime they feel like. What I would say is, for anybody to be punished for your internet access to be taken away, for you to go to jail, you have to break a law. So there has to be a law in place. So in some countries, we know that they already have laws that states, once the state is suspecting you of any kind of activity on the internet, they can just easily take this out. But in Nigeria right now, there isn't so much of censorship of the internet. As an ISP, the only thing I had to sign on for when we applied for our license was basically to block pornography. And so this means that I need to implement all kinds of protocols on my servers, you know, basically using Squid, Dance Guardian, things like that. But then, of course, we know that sometimes some of those blocking can actually be a problem. You won't be able to access some legitimate non-pornographic websites because of some of the blocking. So sometimes you have to actually disable some of that block. It's quite tricky. So looking at this, what I'm thinking is there has to be a balance between whether people, I mean, about who tracks what. That is, who is tracking the criminals on the internet? Who is tracking? Because I think that is the major issue. But then access to information also is something that everybody here, I think, is pushing as a fundamental right. But I think that blocking the internet it shouldn't be an option, because if there's a criminal doing something online, and you simply I mean, it will be easier to actually track somebody down if you are following what he's doing. But then now the question is, there has to be a balance between tracking these people and privacy. I don't know who is going to decide that. Maybe us here, maybe the UN. But there has to be a serious debate about it, so that we know where we stand. Because I mean, governments are all about trying to provide security. But then, of course, we know that they track people too, and like in the case of Pakistan, where you can't encrypt and you can't. I mean, and some people abuse that power. Some governments simply use it to keep their people under their thumb. So there has to be. I'm not sure where this thing is. All right. Okay, and then how this relates to internet governance is, I think that, like I've been saying, it is all about. Already in several countries, we know the internet is a global thing. Everywhere you go, you should have access. I mean, you can get on the internet. But then countries are basically enforcing their own laws in their own way. Every country decides how they want to persecute anybody that they feel is not doing the right thing on the internet. So I think that shutting off of this access, it's a global thing. So I don't think it should be totally, it shouldn't only be governments that should be allowed to decide who gets internet access or not. It should be on a global platform, so that it's a universal thing. Whatever decisions we come to has to be universal. Thank you.
Thank you, Bala. And yeah, it's good. It's great to hear some perspectives from Africa and African countries on what's happening now. And I also just want to acknowledge Frank LaRue, who's just joined us at the back of the room. Hi, Frank. For whom some of these issues are also very, of course, relevant. Anya, I'd just like to move to you, please, and get your perspectives on the answers to those questions before opening up to the floor.
I think actually in many ways I agree with Bidi, so I think there will be quite a few commonalities. But let me nevertheless say a few things. I think it's interesting, the question of restricting or shutting off access is actually about two different things. Restrictions are about stopping content from getting onto the internet. Shutting off the internet is from stopping people from getting off to the internet. And I think that's a very fundamental distinction to keep in mind when we talk about this topic. When it comes to stopping content, I found it really helpful to see in Frank's report, the UN Special Rapporteur on Freedom of Expression, a test that exists of 3 parts that all content that governments intend to block should pass. And basically, the first step is that if content is blocked, that has to be clearly provided for in the law. And that law has to be accessible to everyone, so it has to be predictable and transparent. That's the first one. The second one is that it has to be legitimate, so it has to fall within the purview of restrictions that are recognized under international law, and specifically the ICCPR. And thirdly, it has to be necessary and the least restrictive means required to achieve that aim. Now, it's the third one where I think we very often fail. So what I think you see in the internet age is that very often governments have a tendency to immediately jump to blocking content from actually getting online because it seems the easiest thing to do. It's not necessarily always the best or the most effective thing to do. And I think that third point is something that, as civil society as well, we should start working far more on pushing that as something that has to be a very clear principle in the decisions on when you block content. Speaking about the other bit of shutting off internet access completely, I think, so there's 2 big trends when this happens. Either some countries suggest this should happen when you violate copyright, or in times of emergency or conflict. When it comes to copyright, some of you already know that I like to make the comparison with the right to education. Basically, we are constantly claiming in a place like the Internet Governance Forum that the internet is crucial for people's development, education, political, economic well-being, etc., which is very similar to many of the things we claim of education. But at the same time, you're saying, so if any of us had photocopied more than we should have according to the laws of our land, 3 times in our whole educational career, we should have been stopped from continuing our studies. This is the equivalent by saying if you violate copyright 3 times online, we cut you off from the internet. And I think this comparison shows how clearly out of proportion those kind of restrictions are. So like Bidi said, I think normally when you commit a wrong, the legal system deals with that in a variety of ways. Even if you make a traffic violation, you get a fine. But you don't, unless you actually endanger other people's lives, you're not even stopped from driving a car. So it's, I think, all of these examples show that this as a solution for copyright is just completely out of line. And I think just the fact that these things are being suggested shows that we have not been ambitious enough when it comes to human rights and the internet. I think these questions should not even be able to be raised. This should be something that should not be discussable. I think it's very painful that it is, in a way. It's a little bit more difficult. So I work with the Internet Democracy Project in India, and obviously in India there are times of conflict, of emergency, where there is a concern about communication platforms being misused. And for example, a while ago, there is a mosque that was torn down in the early 90s, and the Hindu right wants a temple to be built on that place. That has been in court for a long time, and a little while ago that judgment was going to be delivered. And the government decided a few days beforehand just to ban bulk SMSs, because they were worried that that was going to be used to create a lot of tension. And when the mosque was turned down in the early 90s, there were riots which killed a few thousand people. So it's not as if there was no reason for concern. For me, that was a good time to kind of think, well, what do you think about this? Because I'm always saying there should be no restrictions, etc. But that was a very tense situation. Increasingly, my answer to that would be that it should follow the same kind of, that same three-principle test that is being set out in Frank's report. And I think that's something that in these cases also are not really being followed. It's not always very clear whether that's the most restrictive means. It's often not clear in law under what circumstances this can be done. And also another thing that Frank pointed out in his report, if any content is restricted, it should always be done by a body that is independent and free from political control. In cases of shutting down internet access in times of emergencies, I think it's very often governments who do that without having larger consultations. So I do think there are situations in which one could argue that perhaps it might be valid temporarily to cut off communication, but I think there needs to be far more thought about when and how and clear procedures of law. Also, just one last point, because the big issue when you cut down communication systems, and you see that, for example, in Kashmir in India, that also means that people don't know anymore what is happening. They can't communicate anymore with each other about, is it safe to go out? Can I actually go and buy groceries now that curfew has been lifted? Where are my children? What are people doing? So it's not just, you don't just cut off the terrorist, you cut off everything else as well. And that creates, the tension that creates actually has the potential to aggravate those situations of conflict as well. So I think the whole balance should be kept in mind much more. I think I leave it there. Thanks.
Thank you, Anya. You always bring such clarity with your examples. I totally love that education example about copyright. Thank you very much. I might use that. And thank you also, Bala, for you know, it's a nice combination of views on those topics. So I'd like to open the floor for if there are questions or comments or observations. I know a couple of people earlier had some. I don't know if they want to pick them up in the context of these questions or if there are new people, Eduardo and also Susan. And
thank you very much, Eduardo Bertoni, for the Center for Studies on Freedom of Expression and Access to Information in Buenos Aires, Argentina. Actually, it was a question, a comment and a question about the defamation issue that you were talking before, and now I would like to also add something about what Anja says about the three-party test proposed by Frank in her tremendous and great report. Defamation is not only a problem in the countries that you just mentioned, it's also a problem in some countries in Latin America, using libel laws, criminal defamation, civil defamation. It's something that is not new as a tool to put pressures against journalists or human rights defenders. I think that the new thing in this area is related to a jurisdictional problem. Because in our region, and this is something that I want to ask you, the legislation is not that bad in some countries and is very bad in other countries. And it could happen that, for example, a journalist criticized the Venezuelan government from a newspaper in Argentina or from a blog in Argentina, and then he or she can be prosecuted in Venezuela because of the content of the blog that was, you know, created in Argentina but was downloaded in Venezuela. The legislation now in Venezuela and Argentina is very different. We in our center, we have been doing a research about this problem. Frankly, we didn't find clear cases or concrete cases that raise this issue, which is the issue of libel tourism that we were discussing in other contexts. But I think that this could be a problem in the future for Latin America. Or my question is, are you having these kind of problems concretely in your region? Are you finding cases from journalists that are prosecuted in a remote jurisdiction, or is just a local problem in the way that the old-fashioned way? And very briefly to what Anja says, this three-party test, what is extraordinary on what Frank says that is that he is applying the three-party test that was in the ICCPR and that was part of the interpretation of the ICCPR before to the internet. But the problem that you raised, the third part of the test, it was a problem in the past, and it will be a problem in the internet era, or to interpret internet cases as well. And that is why judges should be, trained not only in internet issues but also in human rights issues.
Thank you, Eduardo. Would any of the panelists like to just respond to either of those questions?
From journalist perspective, I mean, I hope you know that Pakistan is probably the worst place for journalists. They kill them, don't prosecute them. So.
I don't think there are any particular cases which have these jurisdictional issues in Malaysia. But I would say that have a look at Singapore, because there's a lot of defamation suits happening in Singapore, especially pertaining to journalists. But I can't really tell whether it's on that jurisdictional point.
Jeff?
I was just going to point out, coming from the U.S., obviously with the First Amendment, I think we see a range of disagreements on content issues, and not just on the defamation, but also on the harmful content as well, right? Different countries have different cultural standards, and I agree with everything that's been said, and it just strikes me that regardless of disagreements on that issues, the other process points may form the basis for a stronger consensus, with that being a real difficult thing to get alignment on, as we've seen consistently. But to some extent, are we letting that stop us from agreeing, not us here, but it may be government consensus on, regardless of what your views are, and we can disagree with that, there's a process that you should follow in how you're implementing it.
Thank you, Jeff. Yes, I have this person, you're next in queue, and then I've got others coming. Don't worry, I've got you.
My question goes back to sort of the beginning of the panel and Hania and Shahzad's presentations. I was wondering if you could just speak a little bit about specifically how the repression and the regulations are affecting women and women's rights activists. Hania, you mentioned Sisters in Islam. And is there anything that's different about how that group of, that part of civil society is affected as compared to other parts?
My organization's flagship campaign, and then we are part of the global campaign, and which is APC's Women Networking Support Programs campaign, that is called Take Back the Tech campaign. That's our flagship in Pakistan. Under that campaign, we have been organizing women rights organizations, human rights defenders, and then we were working with vulnerable segments of society as well, and we had included transgenders in it. We included sex workers in this campaign as well, and essentially building their capacities on digital security and giving them tools so that how they can fight for their rights, for digital storytelling, for example. So these is all different areas which we have been working. But then what happens is that suddenly there is some crackdown, and the recent example is that we're organizing our feminist tech exchange in Pakistan, and that was in June, this June, yes. And this feminist tech exchange brought total 18 women. And there were 5 transgenders, and the rest of them were, a couple of them were from media, and rest of them were from sex workers organizations, or and rather understanding that what we were doing in this workshop, it was just a training, and in the national media at one point, because it was reported at BBC, and it was reported very positively, and that what we were trying to do, because we know that our Supreme Court is very pro transgender rights. I haven't seen any other court. I mean, but our Supreme Court really wants transgenders to be streamlined in the normal social processes. They should get jobs. They should be economically well. So I mean, with that perspective, we brought all of them in. And then suddenly, I mean, media definitely. First of all, during that training, we got a call that we need briefing. So the issue is that, I mean, it is difficult to do. There are initiatives which can be taken up. I mean, all these different tools can be used for the betterment, but I mean, it is at times difficult that, how it will happen.
Sorry, I would encourage you also to talk to each other if you see issues. Yeah, okay. So I know that I wanted to move. Okay, sorry.
Okay, just a very quick word about Sisters in Islam. For those of you who don't know what kind of work they do, they're looking at women's rights through, reinterpreting the Quran. So specifically, I mean, I think probably like 3-4 years ago when we were doing a lot on freedom of religion, what had happened with sisters was that they're constantly being attacked, online and also in the mainstream media, especially in this a Malay newspaper called Utusan Malaysia, which is like one of the biggest newspaper with circulation. So they're constantly being questioned about, are you a Muslim? Can you be a Muslim and say all these things? If you're a Muslim woman, why aren't you wearing a veil? And when they speak, I mean, they're always constantly being questioned about the authority to speak on Islam. Their credentials are constantly being questioned. Of course, then there's the usual, death threats against Zai, Ivy. And with someone like, say, Ambiga for the Bersih 2.0, specifically, I mean, because she's Malaysian of Indian descent, so you have this group of people saying, your citizenship should be stripped. For other, there was another female politician, so there was called a raper, things like that.
Thanks, Honey. Matthias, I have you, and then I was going to ask Jeremy Malcolm for a question, but I'll go to you, Matthias, next. Yeah.
Hello, I'm Matthias Kettermann from the University of Graz, and I'm here for the Internet Rights and Principles Coalition. I think what is really important for us all to see is that we don't have to reinvent the wheel with regards to the role of human rights on the Internet. As you've said before, Internet rights are human rights, and existing methodology of applying human rights, including the 3-tier test, are extremely useful and incredibly helpful in implementing human rights all around the world. What we need to do is to build capacity. We have to do that, for instance, through inter-judicial cooperation and through multi-stakeholder activism. That's it for now. Thanks.
Thank you. And the chap in the red, yeah.
Thank you. My name is Norbert Bollo, and I just wanted to quickly comment on the very excellent point we heard about proportionality. Thank you. And from a very technical person's perspective, I would say when you start trying to block content, there is, well, you can try to do it in some ways that are not very effective, that can be worked around at least by technically knowledgeable people. But if you try to think about how could it be done effectively in a way that actually enforces it, it just cannot be done technically without destroying what makes the Internet valuable. I will be happy to explain the technical aspects to anyone who is interested. This is really a fact.
Thank you. And actually, I think it's a good point you raised. There is a lot more collaboration that could happen with human rights people in the technical community to deepen understanding on responses to these issues. Thank you. I know there are several other people with questions, but I also want to move to getting some private sector's perspectives on some of these issues, and there will be more time to discuss some of the points that you've raised. And in particular, to ask Jeff Brueggemann from AT&T, we've posed several questions to you and to Patrick. For example, how well, from your perspective, do private sector remedies and forms of accountability work? Are human rights taken into account when designing complaint system or consumer remedies? And how do these issues relate to internet governance? Jeff.
Thank you very much. It's great to participate in this. One of my, I thought the most interesting workshops I did last year was also on this set of issues, and clearly I think every year it becomes a bigger and bigger topic. So I want to talk a little bit about how we view this internally as well as our perspective on the government issues, because that's as an intermediary, that's a very big issue for us. Internally, I would say our issue started with Pearl Jam about 3 years ago. And I didn't even know this before this happened, but we had a section of our website where we would post concerts of bands as content for our customers. And there was a Pearl Jam concert, and there was editing out of comments between the songs that the Pearl Jam had made about George Bush, who was the president at the time. And we suddenly were flooded with complaints and accusations of net neutrality violations. And so it was a real wake-up call for us that we were not being clear internally or with our customers that when we are an ISP, we are connecting you to any content on the internet that you want to go, and we don't block that. But this was this was us presenting something and making a bad decision, and not, number one, and number two, not being clear about that this was distinct. So we underwent an internal review, and what came out of that was kind of three pieces. One was we had to have a much more systematic approach to content within the company, and we realized that our lives are only going to get more complicated when we start enabling even a message board, right? If you have a place where customers complain, you might feel some people might use offensive language or something. So we realized we had to be very careful to understand which role we were playing, whether it's just the ISP or delivering content or something in between, and have our own internal policies be very consistent. Secondly, we had to do a much better job of explaining this to our customers, that when they're using the different services, to make sure that was clear. And one of the things that we did at the time was to add provisions in our internet access terms of service that made it clear what our position was about not blocking. And then thirdly, it was really one of the things that led us to develop an internal human rights policy, so we would have more of a focus on this. So that was kind of what we had gone through. At the same time, I think we see so I think transparency is a key principle, and this is something that also emerged in the net neutrality context of, to us it was all about defending our right to manage the network, and we were getting a lot of concerns of, well, how do we know, what's a legitimate network management versus not? So we've seen a real push to be more clear with our customers and with the public generally about what is the basis for which we will manage the network, while also reaffirming that, which we now have as rules under the FCC, that we will not block content, from our customers on the internet. So that was kind of our internal. So I think, to me, transparency is a great way to make sure that that companies are abiding by these issues. But what I've seen is growing concerns about the government situation with content. And as others have talked about, and obviously the situation in countries like Pakistan is much worse than in the US, but even in the US we have calls to block child pornography or pirated content. And so we have developed a set of positions on the free flow of information that are actually very consistent with the principles in the LaRue report. And as an intermediary, it's very important to us that both for our customers to enjoy the benefits of the internet and to not get disconnected, as well as to not have us be in the position of making decisions about content. So I would say we have maybe a couple of additions to the points that were made. We certainly support the idea that that there should be a clear and transparent legal framework for unlawful content. This should not be just made by government arbitrary decisions, but we also think that there should be the least restrictive alternative should be explored first. So for example, There are a lot of tools now that can let you filter out your own content as a user. You know, that should be the preference, not not establishing broad sets of harmful content that should be blocked. And then I think the process becomes very important. We strongly believe that the government needs to make the decision about the unlawfulness of content, and that there needs to be proportionality, that the remedy for piracy is not the same as the remedy for child pornography, and that needs to be clearly set out, so that, again, with one of our goals being that we are not in the position of being asked to make judgment calls about those things. And then finally, I'd say that another addition is that we think there also should be clear rules of intermediaries. And we believe one of the foundations of the internet has been the safe harbor protections that intermediaries enjoy, that has allowed us to not be put in a position of being held responsible for what users may do, so that you don't get into this private enforcement issue. And we are taking a very consistent position kind of against private enforcement of these things, which we feel could lead down a slippery slope. So happy to talk more, but that's kind of a quick overview of how we've approached this internally, as well as our position on the government issues.
Thanks, Jeff. And interesting that you echo some of the points that Bala raised about when you're providing a service as an ISP, transparency and who watches the watches. And interesting to see examples where private sector groups are taking public law concepts of human rights and applying them directly in the services and to what they're providing. Thank you. So I'm going to ask next Patrick to respond to the same questions. Patrick Ryan from Google, and then likewise open up to the floor for discussion. Patrick.
Thank you, Joy. Thank you very much for the invitation to be on this panel. I'm pleased to represent the private sector here, together with my colleague Jeff, who's with AT&T. These are obviously issues that affect that affect many people, and private industry plays a very important role in this. Let me just ask a question. I'm assuming. I hope I know the answer, but let me just ask a question here. Who here is familiar with the Google Transparency Report? Can I get? Okay, good. That's almost everybody, and so that's a really good thing. I'm still going to talk about it because it's such since it's such an important initiative in this regard, and speaks to this is really the audience in many ways for the Transparency Report. So Google takes its role as this place on the internet very seriously, particularly as it relates to human rights and content. I don't want to sound like a Google commercial, but there are some interesting statistics here that I think help emphasize the reason why Google takes this stuff so seriously. There are every minute 48 hours of new user-generated content uploaded to YouTube. So by the time that we finish this panel, there will be another 4 months of user-generated content that everybody can watch if they're interested. The Google Apps product, our cloud product that we've had a couple panels on to discuss, is really getting a lot of uptake, and it's really getting uptake in areas where there's low access and people don't necessarily have the money to be able to afford full software suites. There are 5,000 businesses, small businesses that sign up for Google Apps every day, and all of these are with many other products like Blogger form the basis of Google's offerings to the public. And there are many different views, as has been discussed around the world, on what content is appropriate, what content is not. Those decisions are quite varied in different governments. And Google receives takedown requests all the time from different governments, and it's very difficult for an intermediary to process and deal with those requests. But we are subject to the laws of governments and need to comply. And so, in order to help sort of provide transparency on this point, Google believes that sunlight is the best disinfectant. We've launched this transparency report. It's on google.com/transparency report, and it's an initiative that shows, broken down both by country and by product, by the Google products, our takedown requests and traffic traffic flows. And so you can see, if you sort of navigate on it and spend some time on it, you can see, that the internet cuts off, in Egypt at a certain point, or when YouTube traffic is shut down in some countries for certain periods of time. It's visible to everybody. And so we think that's obviously a very, very important initiative, and Google invests a lot of time in it in order to provide a tool for the community here and for others like it. And so I would encourage all of you to continue to use it, because the most important feedback that a company like Google can have for continued investment and development in products like this is the fact that the product is actually used by people. You won't receive any ads on it, and so it's not a product itself that's going to generate any money. And so I'll go ahead and leave it at that, and I think we can probably have some questions.
Thanks, Patrick. And interesting, number of panelists have talked about the importance of documentation and the challenge of doing that. And interesting to see sort of private sector collaborations with new forms of documentation too. I have Susan Morgan. If you could just introduce yourself, and then I've got a list I'm continuing with. Susan, question.
Hi, I'm Susan Morgan. I run the Global Network Initiative, and we've brought companies, including Google, and human rights organisations, investors and academics together, really to look at how to protect the rights of users around the world in terms of freedom of expression and privacy, and particularly looking at how companies can make kind of responsible decisions when they're facing requests from governments that might impact the rights of their users. So I think we've created a set of principles and guidelines that are publicly available in accordance with international human rights standards, and also mentioned in Frank LaRue's report. I guess I'm interested to hear some reflections from the panel, because I think we've heard a lot of things that I hear within GNI that as the internet becomes increasingly central to people's lives, there's a growing interest from governments around the world in terms of how to respond to that, and perhaps how to control or how to manage or how to block access. But what I haven't heard a lot of in this panel discussion so far is the kind of role of bringing different actors together to work collectively. So I think I'm just interested to get some reflections from the panel on the potential for bringing different stakeholders together to either lobby or advocate or work on the improvement of laws or the improvement of the implementation of laws around the world.
Thanks, Susan. Panelists, who wants to respond? Anya?
I do want to respond, but it's not probably as concrete a response as what you're hoping for, Susan. But I think one thing that's definitely from the perspective of India, and I think a lot of other developing countries, one thing that's a real issue is the larger cultural issues around freedom of expression. So there is, to some extent, even among progressive social movements, definitely in India and I think in many other parts of the world, a certain acceptance of censorship to contain conflict in countries that have massive inequalities. That can take a variety of forms. So the lines where, for example, when something is considered hate speech, people might be pushing for censorship much faster than you have somewhere else. Now, what the internet has done is kind of thrown open a lot of things that earlier we managed to contain in ways that the society had some kind of agreement on. I mean, they're democratic laws. And that has kind of completely popped open. So I think one of the things is that it's not enough for stakeholders to just sit together in places like that and talk about these issues in a very narrow way. I think this is part of the problem. We do sit together, but then we get into very technical debates often. And there is actually an issue about a larger culture of freedom of expression and how countries like ours have to evolve to actually develop much stronger cultures in that sense, to be able to deal with this new reality without having that reflex of let's clamp down all the time. And I do think, so in that sense, that should also be a multi-stakeholder effort.
Others? Jeff?
Yeah, I agree completely with Susan, and I think I would just emphasize that I think governments have to be a critical partner there, because I think we feel like they can exert some positive influence as well on some of the countries that are more challenging. And also, I think one of the points I try to consistently make is that we need to set the right example. Say, for example, in the U.S., we need to have our own clear policies, and I think that's not always the case. And I think that the strongest message we can send to our own governments in some of the countries that are generally more open is that we do this the right way and then work with other countries to bring them along, hopefully.
Thanks, Jeff. I have Sonia, and then Grady, and then I see Frank's got his hand up. Sonia.
My name is Sonia Kelly. I work at Freedom House. We have talked about briefly about intermediary liability, and I think much has been said about why this is problematic, particularly for companies such as Google and AT&T and such. But Freedom House recently conducted a study of 37 countries, and one thing that we saw was that individual content providers, so we are talking about small fish here, like individual bloggers, for example, are also greatly affected by such laws. So for example, in countries such as Vietnam, Thailand, and so forth, you have situations where individual bloggers are being held responsible for content that just visitors to their website post anonymously in the commenting section of their blogs. And these people then face either high fines or they're even imprisoned. So as a result, in many of these countries, we see bloggers actually turning off the commenting feature because they just don't want to deal with these types of situations. The second point that I wanted to make had to do with discussion that we had earlier today about some of the laws that are frequently being used to prosecute people for posting information online. And of course, defamation and libel are some of those laws. But what we noticed in our study is that actually broad laws against posting or writing information that is against of so-called national interest or security, or that could damage national economy, are actually the laws that are most commonly used to prosecute people for posting this information on the internet. So because these laws are so broadly framed, anything can be connected to national interests. So for example, in a number of countries, we've seen people who are revealing corruption examples being prosecuted under such laws, or even in more democratic settings, such as South Korea, for example. Many of you may be familiar with the case of financial blogger Minerva, who was detained for about 90 to 100 days because he forecasted negatively towards direction in which Korean economy was going, and this was an offense against posting something that could damage national economy. So I just want to put that out there as one of the huge problems that we've noticed across the countries. Thank you.
Thank you. Just was trying to get the remote moderator's attention there. Do we have anything from remote? No, I didn't think so. Okay. Can I just respond? Please, go ahead, Frank.
Thank you. I just wanted to chime in on a couple comments here. First of all, to make a commercial for GNI, I really appreciated your comments. The Global Network Initiative is is just a great framework that has companies and organizations make commitments. There are a number of companies that have made commitments, Google and Microsoft and Yahoo and a few others, but there's many more opportunities, right? So that there's an opportunity here for all of us to sort of act as evangelists for GNI in order to help bolster it and really really make that work. The second comment is this question of intermediaries and the bloggers and the comments is really a very, very interesting and problematic topic. And it gets to the importance of, Jeff mentioned this as well, the importance of maintaining intermediary liability safe harbors. And the definition of what an intermediary is sometimes just so critical, right? A lot of times, people think narrowly of an intermediary as being, a company like, like AT&T that carries traffic, or a company like Google that hosts videos. But an intermediary can also be just a single individual that has a blog, that hosts comments for a blog. And there are, as you mentioned, people that are going to jail, not for anything that they said, but just for having enabled a comment function. And that's that's a problem. That's an intermediary liability problem, and shows how important it is, not just for big companies like Google and AT&T, but for small individual, netizens on the, that just open up a website and have a blog on their own.
Thank you, Patrick. I've got Grady and Frank LaRue, and then we're going to go to our final panelists, which are from governments. Yeah, I know, I'm sorry, but we might have to move on. Grady, quickly, and then Frank.
Yeah, just quickly, it's more a comment than a question, but I think, Anya Kovacs, you made a great distinction between, blocking content and internet shutdowns, and I like you laid out, the criteria, and that's, I think, excellent criteria for content restrictions. But I think shutdowns are far more severe than that, and if they can be justified, I think the test needs to be far more rigorous. Just quick example, back when Georgia and Russia went to war, the Georgian government was concerned about propaganda coming through the Russian news sites, so they blocked, the Russian sites in Tbilisi, and that caused huge panic. People thought the Russians were on the doorstep because they couldn't get any information. Likewise, with the London riots, they're talking about shutting down, social media to prevent rioters from being able to communicate and avoid police. But the same people using those the same technologies are being used by people to find each other. I mean, as you mentioned, a lot of positives. I think that cutting off communications like that can be far more dangerous, and I would really caution any steps towards opening the door to justifying that. If you ask me, I would say that kind of shutdown is never justified. Yeah.
Thank you, Grady. I'm very conscious of time, and so I'm going to invite Frank LaRue to speak, and then I'm going to move to our last two speakers. Or you want to wait after that, Frank? Okay. All right. That's very gracious of you. So I'll just move to the last section of the panel, really, which is to turn to Romulo Neves from the government of Brazil. And the particular questions that we were asking is, what is needed for remedies and other forms of accountability to be effective from government perspectives, and what roles do governments have in terms of, and what is happening in Brazil? Romulo. What roles do governments have? Yeah.
Okay. I try to be very, very brief, but I'd like to start with some points that is not directly related to this discussion, but it's some background. In the very first beginning of the human rights appearance, it was a kind of tool to prevent abuse from the state towards the citizens. So in some certain way, it puts government and citizens in different points of the discussion. But it's not true, the simple description of the human rights discussion. Because there are governments that just adopt the human rights as some part of its own functioning. And the Brazilian government is one of those. In Brazil, we have a secretariat especially dedicated to human rights in a ministerial level, linked to the presidency. And in the Ministry of External Relations ministry, which I'm part of, we have a special division for human rights, and we work very connected. The Brazilian Ministry of External Relations works very connected. The internal bodies works very connected. So internally, we have this secretariat. We have almost each state has have a secretariat also in the state level. Brazil is divided in 26 states and the federal district. So internally, we are trying to build a very comprehensive human rights system. It's not easy. There is different approach. The federal approach is one. Some very small states and very traditional one has another. But I think we are in a very good path. But this was internally. What government could do internationally, and then I would like to talk a little bit about the Brazilian nature of politics. We are very very fast. 3 minutes more. We are very flexible inside, and it's for good and for evil. And for a long time we were criticized because were flexible, and it means sometimes you don't have too clear rules, and sometimes you have a different way to do things. But I think nowadays we can take advantage of this flexibility, and then we can build bridges. This is a thing that the Brazilian government believes, and internationally maybe we could, because there are two ways to help. One is funding the civil society to make its work, and the other one is to build bridges between the civil society and the governments, because we are, of course, government, and our most important partner in the international discussion are the governments, and we are able to, we think we are able to build bridges between these two stakeholders. And just two things more. What this bridge could mean in the internet governance, because I think this is the most important thing here at the IGF, means that maybe we can try to give some more clarity to some words that some stakeholders just have blocked conscience about it. When some stakeholders hear these words, they just block its consciousness and capacity to hear. So then we have sometimes a deaf dialogue. Sometimes some words, some expressions as human rights itself, some countries cannot hear this, or let's say UN system or cybersecurity, profit, equality. Some stakeholders, when they hear some kind of this expression, they just block the ear. So we would like to help to build this bridge. And the second thing and last thing, sorry, Joy, the internet has a very specific nature. It's sharing, it's international by since its very first beginning, and it's technically linked to development, to technical development. So the internet will force, if you don't do anything, internet itself would force governments to hear human rights demands. But because the internet has a very technical basis, the linkage between human rights discussion and technical, architectural, and infrastructure matters should be, and it will be a very important linkage to put this discussion forward. I think this linkage, this bridge, is also important to the future of this discussion.
Thanks, Romulo. That sounded like a Brazilian government representative supporting the APC suggestion that human rights should be the main theme of the IGF in 2012. So a letter to that effect would be very helpful. Turning to Johan, no, that's very useful, Romulo. Turning to Johan, just perhaps to comment on what other discussions are taking place on these topics right now, and how you think these might be able to be related to internet governance. Johan.
Thanks very much. Just two words on the government's role in this, just to complement what my friend from Brazil said. What Anja said about the culture of freedom of expression, I think that's correct. We need to build that, and I think I come from a country where we actually have a culture of freedom of expression sort of since a long time. We've had constitutional arrangements for this for several hundred years already. So I think we are in a good position to do this work. That being said, the most important thing that the government can do is to create the foundation for this. And the most important thing is to create accountability structures. And you do this by establishing a functioning rule of law system. This is how it's done. So this is what I see as nationally being the most important task of the government. In the international arena, I think that we have many different roles and possibilities to work. For example, when internet was shut down very extensively in Egypt and other places earlier this year, my minister came out strongly and said, this is a violation of freedom of expression. And I saw very few other governments saying this. But this needs to be done. Governments need to articulate their standpoint for several reasons. Because it is a way to show support and solidarity with the victims, but it's also a way of building international law. And this is important. I fully agree with my friend here that there is a need for the technical community and the more traditional human rights community to get together and talk much more closely. But I do also think that we've seen quite a lot of progress in this over the past few years. And this is where the IGF plays a very important role. Actually, this is only my third IGF, but I compared to 2 years ago, and I see a big difference, actually. A big difference, which I think is very important. Sweden doesn't believe that there is a need for any new human rights norms. We think that the norms that we have are sufficient. Strongly support what's being said about the three-part test according to ICCPR Article 19. This is the kind of interpretations we would like to see regarding possible limitations applying to the internet. What we need is to understand more clearly how human rights principles work in the internet context. We need to engage several different fora for this. Our very modest contribution has been to support Frank LaRue's work in a few different ways. We were very happy to see his report in the Council in June. This helped us to understand a little more clearly where the boundaries for human rights application on the internet, where they are. Frank pronounced himself on intermediary role, he pronounced himself on anonymity, he pronounced himself on the limitations, and also on access issues. What we tried to do was to rally support around these conclusions, and together with more than 40 governments, we managed to have a cross-regional statement in the Council on human rights a week after Frank presented his report. This was the first time that many governments came together and confirmed these basic principles. I'm not saying that I think that the Human Rights Council will solve this issue for us. It will not. It's a quite difficult environment to work in. But what I do think is important is that we don't shy away from the main human rights body in the UN, that we try to engage it. I think we're up for some tough times because there are strong opponents to the interpretations that we want to make. But I do think it's absolutely necessary. I think I will stop there. Thank you.
Thank you, Johan, and thanks also for the work that the Swedish government and others have been doing, and it's been good to collaborate. I know some of you in this room have also collaborated with Frank LaRue and his regional consultations as well. Frank, we've been talking about you for an hour and a half. Please, I need to give you the floor. More than 2 days. Please, Frank.
Joy, this is rather embarrassing, but I do thank everyone that has supported the work. One of the issues that I must say is the report, and this is very important. The report is part of a collective reflection. There was a series of regional consultations, one in Buenos Aires, which Eduardo has supported and helped, and for Latin America, we had one in Bangkok for Southeast Asia, we had one in Delhi with Anya for South Asia, we had one in Johannesburg for Sub-Saharan Africa, we had one in Egypt right a week before everything exploded, and finally we had one in Stockholm to end the whole process and to have the European Western group in general position. So it was very good because the idea is that rapporteurs should break a little bit the debate of the four walls of the Palais de Nación and listen what different regions have to say and contribute. A little bit in the line of what Anya was saying, that is oftentimes on the ground, issues are seen in a slightly more complicated way depending on the particular issues and problems that countries are facing. I will be brief, but two things that I really want to emphasize. One is that on internet, I find the same phenomenon that I find with freedom of the press. Everyone will, all the governments and all the state representatives will talk about freedom of the press, but the reality is that more and more journalists are being assassinated and being killed and persecuted. On internet, everyone talks about the fantastic new technology, the fact that it has to be very open and free. And this was my position. Internet works as all issues on and all technology should work on freedom of expression as broadly, as free as possible, and limitation should always be seen as the exception and in a very sort of a small category and very clearly defined was the three-part test. The proportionality part, the last one, is one of those that are normally not taken into account as very crucial. Anya mentioned an example, but we have in Latin America, for instance, was President Correa, who just had a lawsuit against the newspaper El Universo, and the newspaper was fined with $40 million US dollars for carrying an opinion column on that they considered defamatory. Ironically, the government says that they were not very happy because they had asked for 80 million and they only got half. And out of the 40 million, 30 million were personally to be given to President Correa and 10 million to the state. This is an appeal still, but I mean, it was confirmed. Okay, so it's now been confirmed. So this is the absurdity of how defamation and other legal issues are being used to, and it brings back the issue of proportionality, because all four rapporteurs, the three regional rapporteurs and myself, in our statements have said that we believe that defamation should be decriminalized, in Spanish, despenalizado, and should be made a civil action. But even a civil action, if it's out of proportion, can bankrupt a newspaper or any other media. So my feeling is that precisely because the internet is so powerful, we're finding more and more reaction by governments and sensitivity. And the Arab Spring, that for some of us doing human rights was a very welcome and refreshing news, I think for many politicians it was a very scary news, because that happened in Egypt and Tunisia and may happen in Bahrain, Syria, and other parts of the world, may happen anywhere. And I think they're scared. But in reality, this is the issue we have to defend. I mean, our so-called democracies or countries that call themselves democratic really open to hearing their population and to letting them speak their mind, even if there are dissenting voices or if they may say things that those in power may not agree with. I believe we should engage in a campaign of decriminalizing freedom of expression in general, but over the internet in particular. I mean, some are old crimes like defamation, libel suits, but others others are crimes, old crimes based on religion, like blasphemy or defamation of religion in some countries. But there's also new crimes, and this is very alarming. In my own country, Guatemala, they invented a crime now called financial panic. Whoever criticizes the bank or the banking system or the financial system is liable for a criminal lawsuit. In Mexico, in the state of Zacatecas, they just passed a law. This is a state law, not a federal law, on promoting rumors. So now if you promote a rumor, you can also be liable. So I think this is really, really getting out of hand. I mean, obviously, internet has to be used responsibly and obviously is very powerful, and we do mention the cyberbullying and other mistaking issues. But the way to correct it, and has been mentioned here, and Anya mentioned it, but I like that Johan also reiterated, is building a culture of peace. I believe that states, and with this I finish, states before used to be seen as having a passive responsibility in freedom of expression, the responsibility not to censor, not to intervene. I believe now all human rights are an active responsibility, are a proactive responsibility of the state, including freedom of expression. So the states have to facilitate this. And in the case of internet in particular, the point I made in this report and the one coming to the General Assembly is states have to facilitate access to content with plurality and diversity, where there's no monopolies and no one that pretends to own knowledge and own science or scientific issues, access to public information for transparency, access to any form of research, and on the other hand, access to the infrastructure, meaning not only the connectivity, but also meaning computers, meaning software. The Committee on the Rights of the People with Disability have been talking about having free software for those that are visually or hearing disabled, that have or handy disabled, on the possibility using internet. So I think this is crucial for states to listen to this and to facilitate. And to the corporations, there has been a call to do research that makes possible cheaper equipment, user-friendly equipment, to not build conglomerates and monopolies that make more expensive the service. So I think this idea of having a multi-stakeholder dialogue is very important. GNI, as Susan was saying, is a great example, but I think we have to expand GNI. What I like about GNI is the fact that this is a coordinating dialogue around the topic of human rights, and I think this clearly should be, of course I support the APC initiative of the next IGF should be on human rights, but it's also interesting to see in the many times I've come to the IGF how the human rights debate began to grow. This was mainly a technical forum at the beginning, and progressively human rights has become more and more important. I hope that trend continues, because all the technologies and the use of these technologies have to be seen in the light of human rights approach, not only freedom of expression, but what internet does to the right to access information and knowledge, the internet does to the right to education, the right to free association and assembly and mobilization, or the right to development in the world.
Thank you, Frank, very much. And just to say, before turning back to the panelists for some final remarks, Frank has written the preface to the Global Information Society Watch report, which has just been launched, released this morning, which is includes country reports from 60 countries on the issue of freedom of expression and freedom of association online, as well as some thematic chapters. So thank you, Frank. So before allowing you all to go to your much and well-deserved lunch, I just want to give our panelists an opportunity to make any comments, just briefly. Anya?
I'm really sorry. I just don't want to go on record as somebody who advocates for shutting off the internet, so I wanted to respond to Grady. It's the reason I should have been more clear about this, because I very much share your concern. That's also why I made that point about you shut off people being able to help each other and support each other as well. But what I really find problematic is when we speak about the security issue, we deal with it in a very black and white way. So usually governments will say we need more control for security reasons, and we will say no. And in a country like India, even getting people behind you is really difficult when you do that in that black and white way, because in last year, 2010, in Bombay, almost as many people died because of terrorist attacks as in Karachi in Pakistan. And a lot of the government at least makes it sound as if getting access to data, etc., is crucial in stopping that kind of thing. These things are very real for us, no? And you can't just say no then. And so what I think we need to do much more consistently is work through these concerns step by step. And then often the question is, but where do we start? And I just think that this test is kind of a way to work through. And I hope that we come at the bottom of it and then have to say, so you see, it's not a good solution in this case. But we need a process also to make these discussions, rather than saying in this very black and white way, no. There has to be an argument to back that up. I think we haven't been doing that enough.
Thank you, Anya. Very good points. Any other panelists, just briefly before Hani?
I'm echoing something that I heard this morning as well. I think if we're talking about what we could possibly do for the next IGF, I think we haven't had panels or speakers who are from the law enforcement, people from the police, the prosecutors, and the judiciary. Also, I threw out the question about, what are good laws on proof and evidence, perhaps something on that as well. Thanks.
Thank you for those concrete suggestions. I think we've got a number of them that we would like to capture in our report on this session, which we will be doing a report on this session. So, so I just want to, thank you all for your engagement in the session. I think it's been very rich. I think I've heard of many strategies for different forms of accountability. I think we've had some thought-provoking ideas and suggestions. I'd like to just formally announce that APC has launched its Connect Your Rights campaign, which is being displayed on the screen above you. The Connect Your Rights, Internet Rights, a Human Rights campaign is designed to take these issues of human rights specifically into our online lives and connect for us the human rights principles and freedoms that we have specifically in these online environments and with our offline activism and movement building. So we would very much encourage you to be part of this campaign and to participate in it, and we will be looking to take it forward on some of these issues and others across the next year and into the next IGF. Can I ask you please just to thank all our panellists in the usual way?